Our next presenter is already on the screen. That's John Zarian. He's going to take us through a very interesting area, actually, particularly with in this somewhat litigious environment we've all managed to deal with, but a very real concern around candidates for certification who may have issues, physical issues or other issues, and whether or not that does actually prevent them from being certified or not. Just a few words about John Zarian. He is General Counsel and Senior Director of Quality Management at NCCCO. He's been with NCCCO now for 4 years, prior to which, and for nearly 27 years, John's legal practice emphasized intellectual property litigation, as well as complex business and commercial litigation. He's an experienced trial lawyer. He's been recognized by many professional rating organizations, and has been listed as one of the Mountain States super lawyers numerous times. He's actually based in Idaho, works out of the NCCCO's Salt Lake City office. But he's a frequent speaker and a very competent and engaging one. And John, I noticed that you're not actually content just to make presentations in these United States, but I see that you've actually made several presentations outside, including as far afield as Latvia, Poland, and in your, I believe, your ancestral home of Armenia. So the floor is yours.
Thank you, Graham. And as they say, I guess I get around. I'm just taking, I think, control of the screen. If that works, there we go. All right. Well, can everybody hear me then and see me?
Yes.
All right. There we go. Thank you. Well, congratulations, Tara, for a job well done. I don't know why I kept thinking of Kirk Gibson in the 1988 World Series, coming off the bench injured. You're pinch hitting, the power goes off, and then like Kirk Gibson hit a home run in the big game. So well done. Very impressive. I also have challenges. I had to rush my lunch. I only had 5 minutes, so hopefully that'll lower expectations for me too. But here we are, and I'll try to make up a little time talking about testing accommodations. And my goal is to really give you a little bit of background in terms of spotting issues. In law school, they used to teach us, look, you can look up the law, but if you don't spot the issue, then you're really in trouble. You won't know even what law to look up. So that's my objective for the next few minutes we spend together. I'll talk a little bit about the ADA requirements, what it means, what the potential liabilities are, and a few of the big issues to look for and how they affect, of course, certification. The big areas for, well, all of us really on this call are employment Title I type cases and Title III, which is public accommodations by private entities, requires places of public accommodations to do certain things and prohibits discrimination. So there are other titles, applicable to government, other specific provisions, but a little beyond the scope. We'll focus on Title I and Title III. There are other laws too that we won't get into in any detail. States, as you'd imagine, California has more than a few, but states and also the federal government have other laws that apply in this area, and there are things that you need to be aware of for your own state because they can't change definitions. There may be agencies involved that can even affect the remedies that are applicable. So those are things to watch for. So let me talk a bit about Graham mentioned litigiousness, and there's a lot of these claims. Many of them, of course, have merit. I'll talk about a few that maybe don't have as much, but disability cases brought, these are Title I employment cases, are brought to the EEOC through charges. And you see a big number there, 24,000 of these in 2018. The numbers for 2019, I've had a chance to look those up as well, and those are very comparable. It's right around 24,000 again. Retaliation is something to watch for because it's an additional claim. You can bring any one of these other claims and then also bring a retaliation claim if there was conduct that was retaliatory, demotion, firing, or something with the employee that can trigger additional charges with the EEOC. The trend in these, as you can see from 06, say, to the present, has been sharply higher, maybe almost doubled in the number of cases. The red line, you see there's disability cases during that time. There's been a bit of a dip, but over time these continue to grow. But for us, really, the focus is Title III. That's where I want to spend most of the time during this presentation. And what that prevents and prohibits is discrimination on the basis of disability in full and equal employment, goods, services, facilities, privileges, advantages, or accommodation of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation. So this applies to places of public accommodations as well as commercial facilities. This trend line also sharply higher. You see, going back to 2013 and probably even a steeper curve through 2019, the increases in lawsuits filed in federal court on the basis of Title III. Title I cases can also result in lawsuits. Many of those are resolved through the EEOC. In some cases, the EEOC will bring claims or a right to sue letter will be issued, but some of those result in lawsuits too. But Title III is where the bulk of the federal litigation takes place. And most of that takes place in just a few states. You can see California, if you live in one of those three states, California, New York, or Florida, there's a lot of litigation in those three states in particular. Other states have their share, but not nearly what those three states experience. The issues in these cases and the stakes can be high. You can see the enforcement remedies available under the statute, under the U.S. Code. Equitable relief, changes in corrections can be required, damages too, but also penalties, up to $50,000 for a first violation, $100,000 thereafter, and of course attorney's fees, which would and can include litigation expenses and costs. These remedies create good and bad incentives. Good because there's a deterrent effect. Folks hopefully will be less likely to violate the provisions of the statutes, but there have been instances where some lawyers, imagine that, have gotten carried away with the rules and really created a bit of a cottage industry for themselves, filing lawsuits. I have three areas I wanted to highlight in terms of developments in this field, and one of them is a notable case involving just such a vexatious, well, in this case, former lawyer, but this is a gentleman by the name, I think I'm pronouncing it correctly, Peter Stroynick, who had filed hundreds of nearly identical lawsuits against hotels in California. He was, I say former lawyer because he'd been suspended for unethical conduct, but then renewed the filings as an individual, pro se plaintiff, they would call it, and filed hundreds of these cases really with boilerplate. He would say, in essence, I was going to visit the hotel, or I did visit the hotel, and if I had visited the hotel or the website, there was a problem with it. Judge Selman, I've had cases before him, he's a no-nonsense judge, actually declared Mr. Stroynick a vexatious litigant, which means also dismissed the case, but means he needs approval from the court before filing a lawsuit going forward. So there's some bad apples out there, maybe give, well, lawyers a bad name, but some of these claims a bad name. There's, again, claims, many of them with a great deal of merit, but this is a notable case because it sought to curtail some of these abuses by some lawyers. A second area that's really developed is digital access. And so I bring this just to your attention. There's some accessibility guidelines that I've noted there at the bottom that provide some guidance. There's consultants out there helping too. But the idea that websites for businesses must be accessible has gained a lot of traction. There's been a lot of attention given in recent years and may require things like closed captions and the like. That's a big field and a growing area in ADA. And the third I bring your attention in terms of development, of course, a presentation needs to recognize the impact of COVID-19. There have been liability shields enacted. COVID-19 may and generally does qualify as a disability. So these are areas where we have to, of course, recognize that these rules may apply. In general, I would say the ADA allows employers to follow CDC guidelines, but those too can change. And so this is an area where we have to be cautious. It serves also to introduce the concept of a direct threat, because we don't have to go so far in making accommodations as to create situations that threaten others or create a direct threat to others. And so this idea of a direct threat is something that the EEOC guidance in the context of Title I recognizes. There's an old example and guidance given of a crane operator works at a site hoisting concrete panels. This is the example that the EEOC gives. And during a break, the operator swoons, becomes lightheaded, has to sit down abruptly, and the employer says, "What's wrong?" He says, "Yeah, I've been having these spells. I don't know why. They just happen unexpectedly." The conversation at that point really goes not to accommodations for that disability, but really to the threat that's being posed, the direct threat that's being posed. So it's something to keep in mind, that if an employer has a reasonable belief based on objective evidence that an employee may be posing a direct threat, that employer is entitled to require medical examinations and the like to make sure the threat is addressed and understood. But here we are. What is a disability? This is one of the key questions in these cases. Are we really confronted with a disability? Is that what we've got? It's a broad definition. Physical or mental impairment. It could be a person with a history of such impairment, or one who's regarded as having such an impairment. Very broad definition under the statutory provisions. In fact, the definition was broadened. It was broadened in 2008. Basically required in 2008, Congress did that a determination be made without regard to the effects of mitigating measures such as medication. So the question of whether or not there's a disability and whether or not, and this is the requirement, it impairs or substantially limits a major life activity. That's the requirement. Cannot be made basically by requiring that medication be taken before that evaluation is made. So there are some limits on the definition of a disability. A couple of recent cases, one involving migraines and a particular supervisor. The claim in the Second Circuit, this year, by the employee was, whenever I'm around the supervisor, I get a migraine. It gives me a headache. And the court ruled for the employer on the grounds that plaintiff did not have a disability because the migraines only occurred during specific work circumstances and therefore did not extend into major life activities. Another case from the Fifth Circuit involved obesity. Generally, it requires a physiological impairment, but the court ruled that even if that was present in this case, in this particular instance, and involved a claim of hostile work environment, it didn't rise to the level of a disability because, again, failed to show it limited major life activities. And so those are some limitations on the definition. But let me turn in the minutes that remain to the question of disabilities in testing accommodations. And so in the area of testing accommodations, of course, the ADA applies, and so NCCCO and other certification bodies and testing bodies are required to offer examinations related to applications or licensing certification that meet certain requirements. The place and manner must be accessible. It must best ensure that the results reflect aptitude or achievement level, not a disability. Appropriate auxiliary aids must be, or modifications must be made, and reasonable documentation must be requested. There are DOJ guidelines and other guidance on this, but there's some key defenses here too. And the counter, in addition to whether or not there is a disability, typically comes down to one of two notions, two arguments. Does it fundamentally alter the measurement of the skills or knowledge of the exam, or two, does it result in an undue burden? And so this is the recognition, basically limits, in the words of a Sixth Circuit judge, a blind person perhaps cannot become an airline pilot. There are limits to what the law can address in this regard. What does it mean to fundamentally alter the measurement? This is an issue we have faced at CCO. And the main question is, have we changed what a test measures or just how it's being measured? An example I might cite is if there's a certification, imagine, for rifle marksmanship, and someone has a disability and is too short to look over or see or shoot from the particular course that's been set up. Well, in that case, it's one thing to stand on something, maybe a platform, and shoot and earn the certification. That would be a reasonable accommodation. But what if the person has a medical allergy to gunpowder and now wants to, this is a terrible example, I know you're thinking, but wants to shoot a crossbow, right? It still has a trigger, you're still shooting at a target. Is it the same skill, or have we fundamentally altered what's being measured? That's the question in these cases when an accommodations request is made. And so examples of that sort of abound, but let me turn to examples of an undue burden. That's the other big argument in these cases. And the argument would be, in the case of undue burden, a lot of these cases come up under Title I. Remember the discussion of direct threat. What is too much to ask of the employer? So let me give you an example. Employees are required to lift 75 pounds each, and instead one can only lift 50, and so the other employee has to lift 100. That's an undue burden on that other employee, more than that person can lift, and therefore something the employer wouldn't be able to accommodate. It may remove an essential job function, would be another undue burden or example of undue burden. Excessive cost may be an undue burden, and I would note in this area that employees are maybe entitled to reassignment to a vacant position, but the employer is not required to create a position or to promote a person to a position they're not qualified for. So those are the issues that arise. Well, I'm going to close with a word about NCCCO's testing accommodations policy. You can see, I'll just make a reference to, we do have a religious accommodations policy, follows generally the same guidelines, but not part of the ADA accommodations policies. But you see the guidelines there that you can find. I won't belabor them, but we do make accommodations where necessary. And so these things may apply, these requirements may apply. And we follow a process that includes a panel of consulting experts, which will address whether the limitation and the disability involves vision or hearing or physical impairment, could be ADHD or a learning disorder. And then in each case, our expert will prepare a written report. And that report guides our decision. It's a case-by-case evaluation, and it is subject to a right of appeal. Turning to the next slide, we can see that there's a number of accommodations we can make available, whether it's a reader or additional time or the like. Most of these are applicable to written. And that is one thing I would just highlight. One of two is unique on the next slide about our testing accommodations. Some things are unreasonable. We're unique. We have public safety considerations that if someone is certified to operate a crane, it could pose a direct threat if they're not qualified. So that heightens perhaps the scrutiny and the level of concern in some of these areas, but still in all, we do grant, as an organization, accommodations where appropriate. You can see some of the ones in cases of written exams. We've had requests in practical exams too. And one I would just highlight for you, there was a request years ago for a spotter during the practical. There was a depth perception issue, and the request was for a spotter to basically guide the operator as the practical exam was taken. That we argued was an unreasonable burden. So I hope I've been able to identify some issues for you that will help you in identifying these issues in the future and understanding how CCO deals with the question of testing accommodations.